New York VTL Section 1194A explained, "What happens when an under-21 driver fails a breath test? New York takes underage drinking and driving seriously, and a failed breath test can have immediate consequences." Parents and young drivers often wonder what the zero-tolerance rules mean, and this guide explains the law and consequences. New York Vehicle and Traffic Law Section 1194 governs cases where drivers under 21 register a blood alcohol concentration between 0.02% and 0.07%. The law instructs officers to handle these cases administratively rather than criminally, so a police officer completes a chemical test report and forwards it to the Department of Motor Vehicles instead of making an arrest. Once the DMV receives the report, it must schedule a hearing within 30 days to decide whether the driver violated the zero-tolerance law. Unlike adult DWI cases, there is no automatic license suspension before the hearing. This hearing is not a mere formality. The officer must prove each element by clear and convincing evidence. The driver has the right to be represented by an attorney, to present evidence, to cross-examine the officer, and to remain silent. A seasoned DWI lawyer can challenge the calibration and maintenance of the breath machine and test whether the officer followed the proper procedures. If the officer cannot prove one of the 6 required issues, operation of the vehicle, a valid test request, the driver's age, proper administration of the test, a BAC within the zero-tolerance range, and a lawful traffic stop, the hearing officer must dismiss the case and reinstate the license. A failed test leads to administrative penalties. For a first offense with a BAC between 0.02% and 0.07%, the DMV suspends the license for 6 months and imposes a $125 civil penalty and a $100 suspension termination fee. If the driver refuses to take the chemical test, the penalties are harsher. The license is revoked for 1 year, and the driver must pay a $125 civil penalty plus a $100 reapplication fee. Repeat violations increase the consequences. A second zero-tolerance violation results in a revocation for 1 year or until the driver turns 21, whichever is longer, and a second test refusal adds a $750 civil penalty. These administrative penalties are separate from any criminal charges that might arise if the officer observes impairment or other offenses. When a BAC is between 0.05% and 0.07%, the officer may choose to treat the case administratively or arrest the driver for driving while ability impaired under VTL Section 1192.1, a traffic infraction that carries up to 15 days in jail, fines, and a possible suspension. Once the BAC reaches 0.08% or higher, the zero-tolerance framework no longer applies. The driver faces the same criminal charges as an adult, with harsher license revocation periods for those under 21. The administrative hearing differs from criminal court. Formal rules of evidence do not apply, so hearing officers may accept hearsay documents such as the police report. This can disadvantage the driver, but the right to cross-examine the officer is a powerful tool. By highlighting inconsistencies between the officer's testimony and written report, an attorney can cast doubt on whether the officer met the clear and convincing standard and show that the evidence does not satisfy the 6-issue test. Even though the proceeding will not result in a criminal record, a suspension or revocation can affect future insurance costs and driving privileges, so a carefully prepared defense is essential. New York's zero-tolerance law is designed to deter underage drinking, but it also provides procedural safeguards for young drivers. A failure to follow any part of the process can lead to dismissal of the charge and reinstatement of the license. The Kugel Law Firm has experience defending under-21 drivers in zero-tolerance, DWAI and DWI cases. Their attorneys understand how to challenge the traffic stop, cross-examine the arresting officer, and negotiate with prosecutors to prevent an administrative matter from escalating into a criminal case. For guidance or to schedule a confidential consultation, Contact the Kugel Law Firm at 111 E 125th Street 2nd FL, New York, New York, 10035. Call 212-372-7218 today to protect your license, your record and your future.